of these polling stations. For made it clear to your team that there is a need for IEBC to listen and compare. These elections would not have ended up the way they ended up. Every failure which has been the bombers have shown and process results. My Lord, the regional team was a team created by used for this verification is from 34. There is an admission here that even for those agents who were admitted, who participated, they were only given respect of my client and 5,800 votes being increased in respect of the third respondent. Votes were reduced when you compare with this in from 34 respondent my list of authorities. But this court is not satisfactory. I do not think that we can or should even attempt to stand on the way of any kind sought through a constitutional means by appointed. The first respondents have presented they wish this court to consider be the applicable standard in determination. We are that is migration of voters which has not been made within the law. So which has been to the affidavit shows that
these electorals will be consolidated and reported tallying centers at the constitutional level simultaneously. The system is intended to Mount 7 This is a case of the Supreme Court of Namibia, case number SA 1212.
I will not go election and register is mandate fair, but that
compilation of the principal register of voters. So, my lords, for the that is now referred to the Green Book, primary data entry point for all. My lord, the second thing the commission was to move. My lord, my learned senior colleague, Mr. Mohamed Nyaoga, who was before, submitted that there is a my lords, these decision-making processes of the petition. It is registered that the it is, my lord, and
petitioners have put forward as petitions for more, then take a process. They were all put the register, the bioregister of Kipkeno Primary. Some of the instances Mr. Nyamodi talked about, to try shut out the 36,000 people who were in the special register, just so that we can add up numbers for somebody? I don't think so. So the petitioner has not proved this case. And the same submissions would apply absolute connection. In the case of this Masongondi, the first respondent has not lengthy stories about procurement. Went to the
Israel. Take over and strengthening of the court for neither determined which areas it was not. I will have to lead a lot more to say. Please, and I wish you.
positions in government. It achieved all of this in November 20 to retain the paper trail. Ballot has got to be taken out of this. Each ballot has got to the tending the counting.
That of proof is required. In our band of authorities, authority number 41.
Sorry, my laws are signed. Then
must follow the
it does not raise a third world issue complaint about election. What are third world elections known for? 9 to of the register, he can't win an election. Nullify all elections from governor, from members.
decision will make or break.
The state to take constitutional obligation. And my learned friend and his client, the petitioner, wants this court to believe if the machines fail, you close shop. Section says nowhere does he talk about it. The next time he reminded that the election was sham and travesty, my lord. That's the question you should answer. If you say yes, you can. But the 19th register was allowed to because it was in the green. I mean, a perfect election, my lord. My lord, we cannot equate free election to the decide. I mean, South African court, you know, the attack, 2 cases I've given you. He wanted to navigate the country like this.
Of the illustration of the virtue according to the provisions of Article 48. It is wrong to balkanize the country of political parties and the political parties. And obviously, my lord, the political vehicle through which people
in Nairobi Judicial Training Institute linked by to a single network.
Cases that are of public interest have been fact. In this regard, determined.
the circumstances of the petitions
before your choice, and when you decided not to.
Your intervention is well taken. Ensure elect. You see it partly as an electoral court, strictly speaking, and you also see it as the burden of proof being separate from the standard of proof. The burden of proof, if I may remind you, my Lord, I do not wish at that point, except to draw your attention again to those islands of Hong Kong at page 16, my Lord. Just invalidate the declarations made by the Commission. Now, on the face of it, that is not very problematic, except but if I may put it differently, my Lord, if you accept that the underlying voter who is an adult and who does not place in a condition must be made after the my Lord, we submit that speculation
act or regulations, the right to vote, in one sentence, my lords, the relief sought are extremely expansive. The respondent, I'll use the word that I have, which characterize the entire election. My lords, fact number 359, they also found that the process was credible And finally, my lords, our regional body, COMESA, their report is what is before you, my lords, is as a matter of fact, we know no other voting system other than manual. Citizens walk from their residences to polling stations and carry
inability to manage elections. IEBC's conduct is now under scrutiny. ODM has fired the first salvo, calling for the shelving of the process. An ODM parliamentary group attended by Prime Minister Raila Odinga asked the electoral agency to make
opponents, saying, now let's go electronic. My lords, to satisfy or to attain any level of sanity in our electoral system, because you keep on. It is in the affidavit winning Guchu. I come from the school of thought, my lords, that when a lawyer appears before a court, he's not advancing his theories and views, but the positions of a client.
But we need those kids by this end of this month, all of them. Today we are living here very optimistic, cautiously.
The other I pray they are Kenyans. They may not. I am reminded towards the run-up from the jurisprudence from this noble court, the expansion of this process. There's the diaspora, which is the two. And this is also captured in the observer reports. 85 to 95% of cases at the polling side form. The victor of the election is. But even after seeing all that, the manual process must be undertaken for a result to be announced. The presidential chief agent of the petitioner, in his affidavit, my lords, at paragraph 12 of his affidavit, appear in those public. My lords, still on this, I have demonstrated, I hope, that the honor is not with the candidates. It is with IEBC. Are allowed And when they misconduct themselves, my lords, Lords, let me perhaps take a minute of your time. I indicated that a presidential candidate respective candidates. The court opportunity. My lords, having struck out that affidavit, together with all the struck out that massive of Malane, same electoral areas are again a in defiance to that ruling, reintroduce the same complaints is deprived an opportunity to defend himself if tendered at the appropriate time. We now proceed to another request by the third respondent. And the request is as follows. So be it. Sections it is quite to want is understood. You have the in our humble submission, the will of the people ought to prevail. voice across Africa, that the political would have very little role to play in it, particularly so when let us with any seriousness that be undertaken.
But with Congress, unmask the first
to disparage a litigant. That's my submission.
Yeah, and I think we don't need to hear Mr. Regaro. If you
know that we've had all along, you know, it's a great professionalism. But I think we are now moving to those dangerous terrains that we might, you know, regret. That's
very often it is important to refer to the conduct what brings them to court, that very often and is not always supported by the truth. And one of the points I for instance is that in yesterday's petition which I argued, there is then an attempt to support that bad ballots, what you might call fraudulent ballots, should then find their way. Apply provisions of Regulation 77(1), the first petition rejected ballot shall be void and shall. What is good for the goose, my lords, is good for the. He ought to be held to the same standards that he's asking you to hold the IEBC to. But remains mute about the those I think there was an obligation each of the 8 presidential candidates, not in respect of any one of them, but of all 8 candidates. Now, in view of all this, it seems to me this is a personal Kenyans, as he told you in the beginning of his submissions. But as we have seen from the prayers, he's not doing that. He is sticking only it that there is an that clearly it tilts in favor of the people. And winding up on that issue, my Lord, I draw your attention to the very first article of the Constitution. And I have no doubt, my Lord, pointed out, which are on the one hand, personal interest and personal crusade is against public interest, I have no doubt that you will stand on the side of the people of Kenya.
Mr. Gatti, are you ready, or you're donating some more?
No,
time to,
I am ready now, my lord.
to Mr. Nyaoga.
Yeah, thank you. Thank Yeah, donation still goes to the Regero and his clients. My lords, as I indicated, maybe the conclusion may be common, but the methodology is different. And has taken is that this was indeed a healthy contest with his brother and his brothers and one sister. It was a very healthy contest. Of them are actually were. The difficulty now is this. Let us, as 8 candidates, this is his request, let's now allow Kenyans to progress, to heal from their wounds, to get out of the campaign mode, and get on with their day-to-day businesses. My client doesn't see anything more than that from a healthy contest, the contest should now come to an end, so that all the 40 million Kenyans can now revisit or regroup and get on with their work. I have seen my client in all his really comrades and persons who are all credible candidates for this position. Today is him who won. Tomorrow is any one of the others who will win. Citation, make the other 7, or for that matter, offer himself. Because I now want to move to 2 other areas. Issue about a call center called Ken Center. The call center and in that facility, although I do not know, they must have had so many other customers, maybe a bank, a hospital, or anything. A call center, by definition, is a facility that receives calls on behalf of its clients. The call center is by the customers of that the company way and the equivalent of Malaysian bank could have a call in Eastleigh, quite understandably. It defeats logic, therefore, for there to be a conspiracy that because IEB is using Ken Call as a call center, and TNA at one point or the other used Ken Call as a call center, about the totally different system of transmission. My lords will recall before transmission of results from polling station, the electronic transmission followed by the manual transmission. That has nothing to do with the call center. But this, again, conspiracy theory is hashed around a call center. All this is happening, my lords, because it gives you the opportunity, a unique opportunity to take this country forward. My lords, you have this unique opportunity to tell Kenyans that let us live in conspiracy where there is none. Mission of results. And those have dealt with each, my lords, that truly let there be some code of conduct in politics as we expect in other spheres of life. Let them embrace themselves, embrace each other, because not all of them can be county. Today is my former boss, Amos Wako, in Busia. 4.5 years from today, it could be a former client of mine who will be the senator. In all this, my lords, is Mr. Wako has reprimanded me. He says it's 10 years from today that my my client is likely to be a senator in that county. But the point is this, my lords, this contest. It's not a winner take it all. It's whoever. My lords, in doing so, you would have done this country proud, and we shall forever be indebted to you. One or two things as I wind up, my lords. Maybe Mr. Oraro could be getting ready for his final submissions. I do not.
Please donate it to us.
Yes, I'm donating it to the court, not to my learned friend. Because if we could wind up these proceedings earlier, there's nothing cast in stone that a lawyer must submit for all the hours he was given. I deal with another side issue, the Kriegler report, because also that was made one of the pillars upon which the petitions were argued. The Kriegler report, my lords, occupies an important part in our history, particularly the misconduct of our politicians. In all modesty, I had the distinct pleasure of acting for the former CK before that commission, and I appeared before Judge Kriegler, and one of the members is Lucy Kambuni, Senior Counsel. The point is this. This was a commission of inquiry, a very detailed report to government. Parts of its recommendations were accepted, but it cannot be elevated to a statute because it's a situation that took place and which hopefully will never take place again for the remainder of the life of this country. My lords, Kriegler report this petition could be resolved. It should not be used as a threat, as anything other than a report regarding a commission that took quite a bit of time to unravel the mysteries and of our politicians. My lords, you are possibly aware that not too long ago, the petitioner made a public was stolen from him. I sat in this honorable court waiting for that evidence. $7,000 votes. These are the that are crying out over activities in the political arena. Because unless that happens, the politicians can draw us back to a period of anarchy. With those clear messages to our Prince Lords over us. Like in all other contests that other mortals undertake, there must be winners and losers. Us, we have the same origin and the same destiny. Let them operate by the rules of the same game. The rule is winners and losers. And winners and losers are in the my lords, the plea I make not only for the third respondent, but for all held hostage by these political intrigues. Unless my lords have any questions, I still have a bit of time. I could clarify, failing which, my lords, without hesitation, I now donate my time to the Honorable Court. But before I do so, my lords, friend, my good friend and my mentor, Mr. Oraro, has the final word is not to points of evidence. The final word
submissions. In fact, he has been effusive in asking this honorable court to I should state officers of this court. But let us not make ourselves greater. I have not said a single word about my clients. That what I was doing
to replenish.
Again, I would never want to order senior counsel to sit down. It's not fair.
Thank you, my
Please
lord.
listen to the court.
Yes, I do. Thank you.
learned.
Okay. All right.
My Lord, I do believe that my very eminent before we do, that will be within the time allocated to us.
Oh, okay.
Yes.
All right.
I think she will take about 8 to 10 minutes.
Sure.
Thank you.
My lords and my lady, I haven't had
my lady, my lords. In light of the issues that we had before us in petition number 4, but to just speak about our pleadings and the affidavits. With the issues of law that I had wanted to address this honorable court in my final remarks, I will leave it to the reasons that we have already filed. As I'm sure you'd have done anyway, that you take the opportunity to read those submissions in their entirety, because now I cannot speak to them. I therefore request, my lady, my lords, that you allow me an extra 20 minutes on top of my 10 to just speak to the issues that have been said about our case. Thank you.
You want to go there?
Pleadings. Not
no.
Another forum. I do not intend to address that now.
You know, I guess I should consult my colleagues on this one. I was going to be a judicial monarch and tell you exactly what I think should happen, but let me. Mr. Ndea?
Yes, my lady, my lords.
The consensus is unanimous. You have your 10 minutes.
So then maybe they should begin counting. My lords, by way of preamble, the client against the third or fourth the case of the respondents and the just rule of law. Wathoni and Zahid want constitutional organs and institutions that they can trust. In that respect, presents Wanjiku in this matter. The court under which we proceed. The court has ruled that in this petition there must be strict adherence to its rules. It threw out the replying affidavit of counsel for the first petitioners. My lords, in this matter, the second respondent, Ahmed Isaac Hassan, or counsel for, filed the response to our application on Monday, 25th March, and served it on us on Tuesday, 26th March. That is 4 days late for filing and 5 days late for service. It was hopelessly out of time. I had notified the respondent's counsel and the court registry about this. In the premises, the first and second restaurant that is there in our petition. More importantly, those that were received, on time or not, they have not challenged the evidence of irregularities that we have tendered at all. Is admitted and controverted. My lords, the main bundle comprising our petition has 7 affidavits. The affidavit of the first petitioner in the main bundle, in the index and in that bundle, there are a number of things, including an analysis of our petitioner's understanding of voter registration and tallying. It is at pages the additional affidavits from 6 deponents. The 6 deponents they were the makers of those audiovisual recordings, those videos. All personally present when they took those videos. They personally made them. They start how they made the videos and why they're entitled to make them. Journalists employed by Inform Action, an organization that uses audiovisual media transcripts of the videos were done by the petitioner, attached to the petition, the affidavit. Where this is going, my lords, Kenya to IEBC and Safaricom, and reports concerning the entire electoral process from KPTJ. I would just also like to add that the respondents can do many things in this case, but they cannot choose for the petitioners their prayers. That remains for the petitioners to do. It's our prerogative. And finally, my lords, and again, if the circumstances, I'll also finish before time. On the comments made with regard to my colleague, Kathy, I would just like to say, if you didn't read the petition, that, my lords, is attack on a professional colleague or colleagues, commends itself for the type of sanctions that my learned senior Ngatia has made. David versus Goliath. Only now, this honorable court deliver substantive justice in the matter. And my lords, with regard to the allegations that have flown back and forth, I really hope my lords could set up an inquiry where we look at things that have been said about the conduct of lawyers in the course of this petition. Much obliged, my lords.
See, yes, Mr. Oduo. Yes. Did you want? You can use the.
May it please my Lord Chief Justice and judges of the Supreme Court. My Lord, I first wish to start by reiterating is a special court. And the first provision I want to refer you to is the Supreme Court Act. My Lord, the object of the Act are clearly stated in Section 3. The object of this Act is to make further provision with respect to operation of the Supreme Court as a court of final judicial authority to, among other things, assert the supremacy of the Constitution, the sovereignty of the people of Kenya, provide authoritative and impartial interpretation of jurisprudence that respects Kenya's history, traditions, and facilities. Important constitutional and other legal matters, including present constitutional dispensation, to be determined having due regard to the circumstances, history, cultures of the people. And then E, improve access to justice.
We are aware, then you continue with the submissions.
My Lord, I'm concerned that I've had to inspired in this court. So, my Lord, I would like to bring this petition back to where it belongs. That this petition has been filed pursuant to a constitutional right, pursuant to the Constitution, pursuant to jurisdiction. Therefore, cannot be condemned for exercising that. So, my Lord, I'm not going to concern myself or reply to some of the issues that have been raised that fall outside the, because I believe it's clear, the Constitution is clear, and the mandate of this particular court is the court has got to deal with. My Lord, before you are submissions that have been filed by the second respondent in these proceedings. My Lord, I wish you to look at those submissions, and it's my prayer that in light of the content of those submissions, they've got no place we must at all times promote our national that promotes those values in court or outside court. My Lord, turning to the issue of jurisdiction, there is no doubt that this court has got jurisdiction. And Article 138, subsection 4, is clear that this court can be called upon to determine whether or not validly declared, and that is not a misplaced petition. It is a petition in furtherance of a constitutional right, and that jurisdiction is in our law, and we cannot wish it away. So, my Lord, faced with that position, the petition that is before you, the issue of procurement, the issue of the register, the issue of the process, the issue of the tallying, I've listened to my learned friends. They've invited me to look to other jurisdictions. But my submission is this, that our Constitution is unique. And that and declare is conferred on this court. My Lord, for the court to be able to determine whether or not there was a valid declaration, it calls for an evaluation of the process. And my Lord, one of the processes is registration. My Lord, it is true that there is a right to vote, but that right to vote is exercised both under the Constitution and under the Elections Act. The Constitution does not provide for the registration process. An Act of Parliament that is mandatory My Lord, I wish to and my Lord, Parliament specifically conferred that power under Article 88 The Commission is responsible for conducting or supervising the referenda elections to any other elective body or office established by this Constitution and any other election as prescribed by an Act of Parliament in particular. So, my Lord, there is an act sanctioned by the Constitution for purposes of elections. My Lord, I wish to adopt the submissions of my senior, Mr. Oraro, as far as registration is concerned. There is only one register. The Constitution does not talk of a green book. The Constitution does not talk of a special register. My Lord, I'm very mindful of the fact that within our society, we've got people who've got challenges. And it's not the intention of the Constitution to deprive them of the right to vote. But, my Lord, this issue of the challenged persons is a ruse to try to avoid the issue of the principal register. Nowhere did the IEBC declare or state that this is in any document that has been filed before this court. It is a statement that has been made from the bar by counsel repetitively until it is being put forth as fact. My Lord, we urge you to look at all the minutes, the various press statements, the various documents that have been filed by the first respondent. You will find that there is nowhere where the fields are now being given a special register. Special register has changed. In the words of Mr. Hassan, it is 31,000. In the words of some of the councils who've made their submissions, it is 36,000. My Lord, you can see the danger of the uncertainty of not having a register that is certain. My Lord, the petitioner is not in any way saying that the register that was declared as at 18th of February is invalid. What is emphasizing that having represented and made a declaration that the register has been compiled, then that register is the one that should be used and no any other document like a green book. So the submission that we want to annul the register is with respect misplaced. My Lords, you've heard that we want to remove the commissioners from their offices. My Lord, that can not be true because of the special jurisdiction that is conferred on this court to determine whether or not there is a valid declaration. That was completely misplaced. My Lord, dealing with the issue of registration, my learned friend, Mr. Nani Mungai, said there was a constituency called Kasipul Kabondo. My Lord, there is no such constituency polling station. There is no such polling station. And I invite the court to look at the various declaration of polling stations, and I would urge you to disregard all the submissions that have been made in that regard. My Lord, the complaints by the petitioner as to the uncertainty that was caused by this moving register are real. The answers that have been provided have not displaced the submissions that council did make in the first instance. And we urge you to uphold that the only recognized register is the one that was declared by the first respondent on 18th of February this year. My Lords, there are other complaints about the process. You've had submissions of various devices. Submissions have been made that the petitioner was synonymous with the government. My Lord, that is not true. The Prime Minister government. My Lord, the IEBC is an independent body under the Constitution. There may be administrative consultations, like for example, on the government-to-government acquisition of the BVR, but that does not make the chairman of IEBC or the Minister for Justice or any other state officer responsible so that he's culpable or an estoppel to operate against him to raise valid issues on a constitutional platform. On the issue of the procurement of the electronic identification, known as EVID, my Lord, we are not sitting or seeking the court to set aside the procurement process. All that we are saying is that election process, this court must look on what impact that process had on the present elections. We are not asking you to sit on appeal. We are not reviewing, but we are tendering evidence to show that this had an impact on the electoral process has already been submitted. Look at what other countries have decided, and that this court should act with restraint to determine what is before you is the Supreme Court, and in exercise of that particular discretion, it is the Supreme Court that can decide whether or not there was a valid declaration. It is not the election observers. It is not the various organizations, continental or regional, that can decide that issue. It is only the Supreme Court that can decide based on the facts that have been presented before it. My Lord, it's my submission that in execution of what is required of the petitioner, we have discharged both the legal issues that have been admitted, issues which clearly show that the first respondent did not conduct or execute its mandate as mandated by the Constitution and the Elections Act. My Lord, there is no political capital. There are no other considerations. I've heard the economy is going to go down the drain. My Lord, those are, with respect, alarmist submissions. In the petition are bona fides, My Lord, all that we are asking in this petition is that the law is very, very clear. The parameters upon which you're supposed to decide is also very well set in the Constitution. Are nowhere circumscribed within that is to evaluate My Lord, the prayers in the petition have been attacked. And my Lord, we've been accused, or the petition has been accused of being partisan. My Lord, the jurisdiction that is conferred on this court is to deal only with the presidential election and nothing else. The petitioner could not have. That is not a jurisdiction before the High Court. It's my submission that has been made without any evidence, and the same ought to be disregarded. My Lord, you've been urged to act with restraint. My Lord, that is not a parameter which is provided for under the Constitution. The jurisdiction is very, very clear. Examine the facts, and if you find that the petitioner has discharged the legal burden, then appropriate declarations would follow. Nowhere in the petition, my Lord, have we asked, as has been stated at paragraph 2.1, that we seek the annulment of the entire general election. My Lord, reliefs do not vitiate which a party is entitled to make to the court. Whether or not they are granted is for the court to decide. My Lord, the role of technology has been the subject. It's my submission that we have made our submissions on the representations by the first respondent. We have analyzed what the law provides, and our submission still remains that technology had an important role to play in this electoral process, taking into account the outline of the origin of the present Constitution, the mischief that technology was intended to cure. My Lord, there's been an argument which has worried me considerably, that the law does not matter, and therefore the IEBC can flout the Constitution, can flout written law, and the Supreme Court is expected to uphold such flagrant violation of the Constitution and the law. My Lord, the position that I want to put forward is this: that the IEBC is subject to the Constitution and the law, and if the court finds that they failed in their constitutional mandate or statutory obligations, then there is nothing that will stop the Supreme Court from making appropriate declarations. So, my Lord, with that, I wish to adopt in full the submissions by Mr. Oraro. And my Lord, before I sit down, the issue of the evidence in the struck-out application is worthy of comment. My Lord, it is true the affidavit was disallowed. But before you, we have the green bundles, which is evidence that is presented by the IEBC. My Lord, it is within counsel's right and is not prejudicial that comments be made on the evidence that has been tendered. And my Lord, that cannot be abuse of process. That evidence still remains on record. The relevant Form 34s are before you. You'll be able to look at them to see whether or not the issues that are raised in the submissions are true or not. My Lord, finally, when you retire, to make a determination, having looked at all the evidence that has been placed before you, what you have to decide is this: did the constitutional threshold of 50+1? That is the crux of the issue. That is the crux. And my Lord, the provisions of Article 138, subsection 4, it's not an empty article. It is contained in a constitution that was endorsed by Kenyans in a referendum. So the will of the people of Kenya My Lord, Article 3 is instructive. That to proceed contrary to that mandatory article will be a violation of that constitution. And this court has got a duty, like all of us, to uphold the Constitution. Those are my submissions, my lords.
My lords, I just stand to thank your lordships for your patience on what has been a very long and arduous undertaking, in the course of which I think the patience of all of us has been tested. Mission. I would request that we leave this court having forgiven each other and marching forward as soldiers of the law to undertake other litigation, not necessarily for our protagonist clients. I thank you, and I wish your lordships well in whatever decisions you will come up with. Thank you.
You leave the court tomorrow. We're going to request that around 8 a.m. tomorrow. You can pick the results of the scrutiny that we ordered so moto, and we would like you to address us on that at 10 for 1 hour. They will be available in the registry anytime after 8. Tomorrow. Tomorrow. They just completed, they're just doing the final bits, so you can pick that. And then we'll hear you for just 1 hour so that you have an opportunity to comment on the report on that scrutiny.
No, it will be 1 hour for everybody, or?
No.
Yeah, 1 hour each.
No.
Actually, if I may say something, we did in good faith. We wanted to learn about all these documents, and we called for it, and maybe we expanded it to include even some of the papers for some more polling stations than the 22. So since we did it openly and had agents come and your representatives, we thought that we cannot close without your participation. Disputes but you have a right to see the results and give your final comments. Maybe we'll give you 10 minutes each, and within 1 hour we finish.
Thank you,
Yes.
With your permission, my lords, may I also join my learned friend, Mr. Oraro, in thanking my Lord Chief Justice and my lords for being so patient with us. We trust and pray that although we are doing a political contest, we did it with. If we failed in that, I'll be very ashamed. But if we did it with the decorum you'd expect from practitioners, we are very thankful, whatever the result. Thank you, my lords.
Okay, we have the Constitution to thank for holding night meetings. So we'll meet tomorrow at 10. Sure. Thank you. So somebody is going to bring this, but I can take this.